The topic chosen for today's evening function should have been the merits and demerits of the communal violence bill, and not that it is a threat to national integrity is concerned, because the focus will be narrowed down and it will be limited, and I may be pardoned to say that it will be politicized. And I don't want that to happen, because the bill should be discussed in a very congenial manner. Moreover, what we are required to do is to give our thoughts or views on the bill and leave it to the public at large as to what would be the consequences or after effect of the bill if it were to become an act. Further, we may also have to apprise the public at large whether there is a need for any such law at all. Our focus should be on these issues. In this context, we have to see whether the existing law will not take care of such violence and whether they are proved to be ineffective all these days. Kindly remember, the field here is communal violence. I repeat once again, the field chosen for the bill is communal violence, not the violence against any particular community. So when the field here is communal violence and not violence against any particular section of the society, that being so, whether the provision of the bill or the provisions of the bill will have any nexus to the object. Because if you go through the bill, the preamble of the bill gives the object, and when you go through the text, normally whenever a law is framed, the body of the law must have some nexus to the object. So we have to see whether it has got any nexus to the object stated in the preamble of the bill, and whether it offends the equal treatment and equal protection of law enshrined under the Constitution. Parliament and the legislatures cannot transgress the basic feature of Constitution, namely the principle of equality enshrined in Article 14. What is necessary element of the rule of law is that the law must not be arbitrary or irrational, and it must satisfy the test of reason, and the democratic form of polity seeks to ensure this element by making the framers of the law accountable to the people. Unequal treatment by hostile intent. I repeat once again, unequal treatment by hostile intent will amount to patent discrimination, offending Article 14 of the Constitution. Article 14 condemns not only by a substantive law, but also by a law of procedure. So for the present bill is concerned, it is not merely a substantive law, but it is also a procedural law. So what Article 14 says, it condemns not only by a substantive law but also by a law of procedure. if there is no nexus between the basis of classification and the object of the act under consideration, then Article 14 of the Constitution forbids such legislation. The object must be supported by reasons. When you want to make a bill, you state in the preamble the object, but that will not suffice. You must also come out with statistics. You must give the reasons why there is a need or necessity for such a bill or for such an enactment. So that's why I say the object enshrined in the bill or stated in the bill must be supported by reasons to make such a discrimination. There must be a reasonable basis to differentiate. Article 14 guarantees to all persons the rights of equality before the law and equal protection of the laws within the territory of India. If there is an involvement of unfavorable bias, then it is discriminatory, offending Article 14. If such bias is disclosed, then it will incur condemnation as violating constitutional prohibition. Of course, to some extent, my predecessor speaker has made an attempt that it will incur condemnation as violating constitutional prohibition. It must be shown that the discrimination is rational and has nexus with the object intended to be achieved by the said bill. Any classification which has no basis is irrational and arbitrary. Similarly, it must bear a reasonable and just relation to the object of the bill. The bill to be valid must not offend Article 14 in a nutshell. Then in this context, of course, if you read the preamble of the bill, it makes a very fine reading. But what are the historical reasons and experience for the makers of the bill to come out with such bill must be discernible in the bill itself. Of course, Rakesh Sinha has provided certain statistics which are rather alarming. If you go by those statistics, probably the bill has to be condemned at the threshold itself. And that's why I said the bill to be valid must not offend Article 14 means what are the historical reasons and experience for the makers of the bill to come out with such bill must be discernible. What is the rationale behind such legislation must be disclosed. The classification must be founded on an intelligible differentia which distinguishes persons who are placed in group. Here the reference to the group is the group as defined in the Cabal and Violence Bill, not the other group, the group and the victim. These are the two definitions which have been the subject matter of attack by almost all the academicians as well as the intellectual people. Then, which distinguishes persons who are placed in group from the others who are left out of the group. Such differentiation must have rational relation to the object sought to be achieved by the bill. There must be a nexus between the differentiation, which is the basis of the classification, with the object sought to be achieved by the bill. As I have already stated, Article 14 condemns discrimination not only by substantive law but also law by procedure. In this context, it is to be seen whether the bill stands the test of law. Whether it violates equal protection of law guaranteed by Article 14. Is there any reliable statistics or other material to support the inference that it is only the majority who has been an aggressor and the minority is always at the receiving end, and that the whole of the police force has not acted in an unbiased manner? Whether the existing laws are not sufficient and adequate to protect the interests of the minorities? Is there a material to show that communal violences are always at the instance of the majority and the minority is in no way to be blamed, and that the law enforcing agencies have not acted independently and they have always been biased towards the majority? If there is no dependable material in support of the rationale on which the bill is founded, then certainly it will offend Article 14 of the Constitution. And it creates an impression that it makes hostile discrimination between the two groups in the same country. It may seem to be unreasonable and arbitrary as the choice of the group is made keeping in mind only a certain group in mind, ignoring the vast majority of others who are also entitled to equal protection of law. Thereby it gives an impression that it is one-sided. The interests of both sides have not been kept in mind whenever there are such violences. In that event, it gives an impression that the bill has been made keeping the interest of only one section of the society and not the other, and thereby it violates the principle of equality enshrined in Article 14 of the Constitution. As has been rightly said by my previous speaker, that this bill has been brought out keeping in mind only two communities. So far the scheduled caste and scheduled tribes are concerned, even if you go through the provisions of the bill itself, it says that there is already a law to protect their interests. That means it is not meant to further safeguard or further insulate so far the scheduled caste and scheduled tribe people are concerned. It will only duplicate the law which is already in existence. Then the other minorities which we are left with are the castes which have been named by Rakesh Sinha. And thereby it violates the principle of equality enshrined in Article 14. The definition of group and victims, if you go through the bill, the definition of groups and victims